proceed. Now, without a deed, all legal transfers of land titles, interest, rights, and ownership will be void. That's the only way to transfer ownership. The only way. It's not deceit. So if you paid and didn't get this deed, it's still void. You're not the legal owner of that land. Are we learning? Are we enjoying this class? Okay, let's proceed. So from now, you can understand how important a deed is. Yeah. In my own opinion, I would say, before anybody starts selling land, they should undergo probably a 1-year course on these things before they start selling land. Because people don't know what they are selling. When I started studying these things, I'm like, hi, I've just been doing this business. This is the heart of the business. It's not commission that is the heart of the business. If you reach a commission, then it's time to commit it. So let's proceed. So there are so many types of deeds. So when you hear deed, it's not restricted to deed of assignment alone. The deed of deeds, deed of sub-deeds, deed of gifts, there are so many of them. Somebody can give to a land, and you need a deed of gift to transfer the ownership to you. Yeah. So there are so many types of deed. But the word deed, that concept of deed is what we use in transferring all those things to the person. So that's beautiful, that's clear. Let's proceed. Now let us dissect deed now. We want to look at parts of deed. And because of that, I think we have a copy of the deed here. Okay. It's a copy of the deed. I think it came with some. I think we are familiar with something like this. Yes. It must not be blue. Everybody is using blue. What's important is the document. So this is a sample. This is a sample of a deed of assignment. You want to look at the parts. So when you pick this document, you know what to look for. The fact that it carries deed of assignment here does not mean that you should rush and sign it. You know, in the beginning of this class, I said there was a situation where somebody titled a document deed of assignment, but inside the document, the content was a lease. And lease is restricted document, restricted title. You are given temporary possession of the property. I can give you my farmland to farm it for 10 years for 2 million. The fact that you are possessing that farmland does not make you the owner of the farmland. So what I'm supposed to do is I'm supposed to prepare a deed of lease and you sign it. Lease is from 3 years onward. There are some leases that is as much as 5 years, 50 years. Yeah, like I said before, 60% of the properties on the chart are under lease agreement. Yes, 60%. Because they don't want to sell their land. If you come and say, okay, we're going to give you this land, build shops or plaza, and after 50 years, your hands off. Yeah, and if you do your calculation, you see that by that time you must have recovered your capital, made your profits, and then you sign it. So, but then let us go into what we're looking at. Parts of a lease. Now, particulars of parties. Like this one in my hand. Particulars of parties. I need one of these things to be going around so that people can just look at it. Like this one now. Look at the particulars of the parties. The owner of the property has signed up to P1 Precious. See the name P1 Precious is there, right? And then you also see the address of the company. Plot 37 Kenga Layout along Onitsha Enugu Expressway, Oka, in Oka South, local government area of Anambra State. So the seller is also called the assignor. In lease, this will be leaseor. Okay, so this is the particular of the seller. And then you now have this person, Mr. Ifeanyi Afonso. With his own address, he is the assignee. In the case of a lease, I mean a leasee. Okay, so the particulars of the parties involved has to be in the front here. Normally their name and their address. At times, they will always include the local government where they come from and the state where they come from. Okay, that's the first thing you want to look at. particulars of the parties, name, addresses. Designation means maybe if it's a Mr. or Honorable or Barrister or whatsoever. Okay. And then number 2, particulars of witnesses. Witnesses must be in the deed. Their names and their addresses. Number 3, description and location of the property. Very, very important. Description and location of the property. Now look at this. In respect of one plot of land known as Owobo Land Block C, Plot 12, from Precious Garden Estate, lying and situate at Owobo Land, Udezu Village at Charlottetown, in Okano local area of Anambra State. So you see, a description of the location of the property must be in the deed of assignment. How many of you have signed this thing without even knowing where it is written in your deed that this here is your place? Some of you, how many have read this thing by signing? And you check that it's the same location you're signing. Because these are some of the things that are very important. They may give you a deed, and the deed is describing one land in Asaba, but you're signing for Oka. Yes. Especially when you're dealing with a company that doesn't have reputation. There's a lot of companies that are doing magic. I'm telling you the truth. So this most of the companies that are coming up, and then I just they want to make all the million. Most of them are doing fraudulent things. That's why they only teach their realtors how to make sales. They don't teach them these things. Because if they know, they might stop selling for the companies. Yes. This is an empowerment seminar. A very serious seminar. Okay? So you must be able to see the description of the location of the property. Very important. Let's proceed. Number 4, the reciter, what we call history of the land, or what we call root title. The reciter, that's very, very important. No land is just coming from no space just like that. There is a history of ownership of that land. So let us check if we have a reciter here. We'll open this. Okay, contact from this warehouse. Now, if you open this first page, it still states the particulars of the parties involved. And then after that, you now see warehouse. The assignor is a reputable real estate company, duly registered under the relevant laws in Nigeria, with purpose of providing satisfactory homes or properties for their subscribers. Number 2, the assignor is the beneficial owner and in exclusive. You see this place? The assignor is the beneficial owner and in exclusive stroke absolute possession. What it means is that this particular estate absolutely, not restrictedly, belongs to P1 Precious. I get it now. Absolute possession of all the properties of land known as Owobo Land or P1 of Precious Gardens Estate, lying and situated at Owobo Land, which is the village at Charlottetown, Okano local area, Anambra State. The assignor derives its interest, so rights. This is where I need to pay attention. The assignor derives its interest or right of the said Precious Garden Estate after purchasing same from and the assignor has remained in absolute possession of the said Precious Garden Estate peacefully and uninterrupted and has enjoyed same without any form of disturbance by its vendor. So it gives you that brief history. But then, in some cases, there's going to be a step further into whom the welfare got the land from. You could say that the welfare got the land from their ancestral land and it was given to them by whatsoever. Understand? There's some cases where you will see about 2 to 3 or 4 lines of possession. Especially when you want to buy from an individual and the land happens to be probably in an urban area. In that case, the reciter should give me even the first owner. Maybe Mr. Chooks inherited it from his father on that customary acquisition. And then Mr. Chooks sold it to Mr. Emeka. And then Mr. Emeka sold it to Mrs. Oluchi. So there's going to be a brief history of the ownership before it got to your turn. Because the new deed, if you want to sell it, will still contain that history and then contain you selling to the new person. So that is what we call the reciter or root title. So if you pick a deed and you don't see that, it means there is a problem. It means there is a problem. If this Mr. Ifeanyi wants to sell this land now, in the reciter, he's going to mention the welfare, mention P1 precious, and then him selling it to the new person. Then the new person, if he wants to sell, you see how the root title keep increasing, so that I can go and verify. I say, okay, you bought it from this. Actually, this man, you don't buy it from Mr. A. He says I bought it from him. But Mr. A, you bought it from P1 precious. I came, I found that it should here. Then I now ask the welfare. The man will say yes. So I can verify the land. Okay, so that's what we call the reciter. It's very, very important. I always look at it when I want to sign documents. If it's an individual property, you will show me that man. I will ask, who is this Mr. D that sold this person? If one asks, can I have his number? Where does he live? I was about to say one property in January. I asked. I traced up to the third person. So yes, I was the one that sold it to this person. That's one of the ways to do due diligence. Okay? How many of you knew that there was something like this and you never said it? How many persons? Because the land is not the ownership is not of space. There's an issue of who has owned that land before. So one of the ways to be sure it's authentic is to be able to identify the history of ownership. It's called reciter. Okay? Now let's proceed. Consideration. You must also look for the consideration. Consideration is what was paid to own that property. It must not be money. You know that? It must not be money. We can have an agreement that if I sweep this place, or that's going to give me 1 plot of land in one of the estates. That service is a substantial consideration for the land. In as much as we agree. So consideration must not be money. It could be service. It could be a gift. Yes. Anything. My car can be a consideration. Okay, I'll give you my car. Give me 2 plots of land. Give me 3 plots of land. So when you want to sign deed, check for the consideration. What is the consideration? In most cases, it's going to be the amount. It's stated here. Let's look at the consideration here. Look at it. I'll read it from clause 6. The assignee is desirous of taking assignment of 1 plot of precious garden estate from the assignor, and the assignor is equally willing to part therewith the said 1 plot of the said land for a consideration of 2,300,000 naira in words of the pico. Hence this agreement. You see, they call it consideration. Now ask again, how many of you has always checked the consideration of the land that you sign? How many persons? So you see, it's important to know all these things. When you sign the land, there is no consideration. So what was the substance on which the agreement was held? Every land transaction, every agreement will always have a consideration. It must. Next, covenants and undertakings. Covenants and undertakings. This is where they now say that this person has full ownership or this person has restricted ownership. Let's see the covenant here.